unconscionability for business law. It's Maggie,
Abby,
Adia, Kristen. Yay!
Yay!
What is unconscionability? Unconscionability is a defense against the enforcement of a contract or portion of a contract. Typically, contracts are most likely to be found unconscionable when unfair bargaining or unfair substantive terms are present. Okay. What we think. We think unconscionability is a legitimate legal defense that protects people against grossly unfair agreements. Unconscionability does not favor either party. In most cases, both parties break even and there's no monetary compensation, meaning no money in exchange. Procedural unconscionability is based on factors like consumer ignorance, unexplained fine print that serves to deprive the party of a meaningful choice. This relates to the bargaining process that occurred before the contract was finalized. In other words, this means that the negotiation occurred before the contract was signed, had major problems, and needed to be negotiated better.
Substantive unconscionability arises from the terms within the contract and from terms that are found to be one-sided, unjust, or overly harsh. That means it can be voided, even if it's signed by both parties. In other words, it concerns the content of the contract, not the process that took place before signing it.
How does this void a contract? If a court deems a contract to be unconscionable, the contract is typically declared to be void. Both parties walk away without further involvement. Again, to recap, usually both parties aren't rewarded any compensation at all. Now we're going to talk to you about some cases involving unconscionability. First up, AT&T Mobility LLC v. Concepcion. J. Lewis v. Epic Systems Corporation. Rockin v. California. And Sosa v. Paulos. AT&T v. Concepcion. This case was decided on April 27, 2011 in the Supreme Court of Utah. The Concepcions bought a new phone through AT&T. AT&T was advertised this phone as free, failing to inform the customers that they will have to pay the sales tax. Unfortunately, when the Concepcions realized it, they had already entered into the contract. The claim against AT&T turned into a class action, and the Concepcions told the court that the agreement was unconscionable. The courts agreed since AT&T was in an unfair position compared to their customers by withholding the information about the sales tax. They were tricking their customers into the idea of a free phone. J. Lewis v. Epic Systems Corporation was a U.S. Supreme Court case that was decided on May of 2018. The case was about Epic Systems sent an email to all their employees saying that it had to be accepted to continue their employment, containing arbitration agreement mandating the wage and hour claims could only be brought through individual arbitration, and that employees waived the right to participate in or receive money or any other relief from any class, collective, or representative proceedings. Lewis sued in court under the Fair Labor Standards Act, arguing that this was unfair to employees' rights and very restrictive. The U.S. Supreme Court agreed that this is unconscionable. The Seventh Circuit denied motion.
Rockin v. California. Rockin v. California was a United States Supreme Court case that was decided on January 2nd of 1952. The issue was if state officials are able to use force to extract evidence from mouth, throat, stomach of their criminal suspects. Major facts about this case was the LAPD entered Rockin's home without any arrest or search warrant. They were looking for narcotics, particularly morphine that he may be selling. Rockin had 2 pills on his nightstand by his bed, which he then swallowed. The LAPD took him to the hospital and forced to pump his stomach. After finding the evidence, Rockin was arrested. Once he went to court in California, Rockin was convicted after the evidence was found. The United States Supreme Court reversed the conviction due to the fact that the LAPD violated Rockin's right to due process of law. The reasoning behind this decision is that the 14th Amendment of Due Process Clause outlaws conduct that lacks conscience.
Sosa v. Paulos, heard in the Supreme Court of Utah in September of 1996. On November 6, 1991, Sosa signed documents including a physician-patient arbitration agreement and consent for use of freeze-dried and flesh donor tissue 1 hour prior to her surgical procedure without staff reviewing the documents with her. After the procedure was completed, surgical complications occurred immediately, and a claim was filed in July of 1994. Dr. Paulos argued that the patient had time to review the documents and ask any questions regarding the information, but due to the patient being in a gown and prepped for surgery at the time of consent without knowledge of the contents within the documents, this was deemed later on unconscionable. Thanks for watching our video. Does anybody have any questions? If not,
Piss off.